The Wayfarer parties just opposed Blake Lively's motion for attorney's fees under California Civil Code 47.1. They raise some interesting legal arguments. First, they raise what we've been saying all along, that this is a new law, and any adjudication on this law would be an issue of first impression, which is usually left for the state courts when dealing with a state law. And so there are some constitutional challenges, some potential legal conflicts within the code that have not been dealt with in California courts. And so asking a federal court to do so creates a tension that a federal judge would want to avoid. Next, they go into how 47.1 does not necessarily apply extraterritorially, meaning that there's nothing in the actual statute that says that the California legislature intended for this statute to be applied to outside of the state of California. And here, plaintiff is a resident of New York. All of the conduct that she alleged was harmful happened either in New York or New Jersey, not in California, and that she has failed to show a nexus between the conduct that happened and California. They preview that this is the same legal concept that applies to FEHA. FEHA is the Fair Employment and Housing Act, which is the law that Lively has brought her hostile work environment and retaliation claims under California law. There is a federal Title VII counterpart, but she brought her California-specific claims under FEHA. And under FEHA, you can't just sue a California employer for stuff that happened outside of California. There has to be some kind of nexus, some kind of connection. If you're alleging that there was retaliation, for example, but you're not in California and your boss wasn't in California when it happened, and you're saying, well, my employer is Californian, there has to be something showing that the bad acts happened in California. So let's say the claim is that you were demoted. Your boss and you yourself don't live and don't work in California, but you work for a California company. And you'll have to show that the decision to demote you was made not only by your manager who's outside of California, but people and players inside of California that had some kind of sway on your employment. That would be a way to show nexus between the bad act. So here they're saying that there is no nexus. Lively is a resident of New York. All of the conduct that she alleges was harassing occurred outside of California, despite the fact that Wayfarer is based in Los Angeles and is a California employer. All of the conduct that she's alleging happened outside of California. I suspect that's something we will see at a motion for summary judgment about whether or not her FEHA claims can survive because she has alleged that the conduct occurred outside of California by people who were also outside of California. Now, to be completely fair, that is prickly. It is going to be a lot of pulling apart of facts and case law, applying it there to determine whether or not the specific conduct and by the specific person happened outside of California. So that's going to be really interesting to read how the parties flesh that out. But I expect that to be an issue that comes up in summary judgment. The argument that I was waiting for is argument C in their opposition, which talks about how that 47.1 privilege only attaches when there is a communication made by an individual without malice regarding an incident of sexual assault, harassment, or discrimination. So that piece of it without malice is actually really, really important and has an entire analysis that goes along with it. They start to dive into that. My phone died in the middle of trying to film this. So to recap, a communication about harassment, discrimination, etc. is only privileged under 47.1 if it's not said with malice. And malice is defined in California law. Conduct that's intended to harm someone or it's willfully disregarding that it could harm someone, that would constitute malice. So if any of that is associated with the statement about harassment discrimination, then it wouldn't be privileged under even how this law is written. Now, there's an interesting question here that I haven't researched, but whose burden is it? Is it the burden of the person claiming the privilege to prove that it wasn't said with malice, or is it the burden of the person claiming that the statement was made with malice? In any case, I think it's the latter, by the way. In any case, that requires its own evidentiary journey, evidentiary hearing, and analysis to determine whether or not the statement in and of itself constitutes malice or not, which seems to me is a preliminary question as to whether or not the privilege attaches. Because first you have to determine whether or not the statement was even said without malice. So there's that. That's another kind of statutory issue with this civil code. And here they're saying that a crux of the defense is that Lively's statements were made with a poor intention. At the very least, there was some intention of harm behind the statements that she made. Are you discombobulated yet? To add a further layer of complication, this statute says that you can seek punitive damages. In order to seek punitive damages, you need to have actual damages. And you need clear and convincing evidence that the defendant acted with what? With malice. So then it's Lively's turn to prove that the Wayfarer defendants brought their defamation claim against her with malice. In other words, with the intention to harm her. The law is so chaotic, it doesn't even make sense. There are so many potential pitfalls with this judge ruling on this motion. I really don't think that he will do it. At best, I see him tabling this for something to decide after trial, but there is no way that he is going to touch this right now. Of course, crazier things have happened. Of course, my prediction could be wrong, but based off of what I know about how courts operate, and based off of how this crazy statute would play out, it does not seem worthwhile for the court to take that kind of risk when it could just delay it until a later time, hoping that things get resolved before then.